So here is a quick overview of the Uniform Commercial Code, sections on sales and secured transactions. The Uniform Commercial Code is not itself a law. It is a model law or a template intended to encourage uniform legal terms for contracts for the sale of goods across the whole U.S. All states have adopted similar, though not necessarily identical, versions of the UCC. So uniformity is achieved, but you still need to check the details on a state by state basis. The UCC applies to contracts for the sale of goods valued over $500, but all other contracts, employment, services, real estate, and sale of goods that are valued less than $500 are governed by common law. The UCC also provides a framework for leases of goods and secured transactions, as well as a number of other business financing actions like fund transfers and letters of credit. Just as you can contract around a tort, that is, agree by contract that someone won't be liable for something they might otherwise be liable for, you can also agree, if it's in writing clearly stated, to contract to terms other than those that are in the UCC for the sale of goods. Vermont's UCC is found in the state statutes at Title 9A, and I've provided a link for that in the materials in this module. So take a look at Title 9A, sections 2105 and 2107 regarding the definition of goods. You'll see that there are specific provisions regarding things that attach to real estate, like crops and timber, and there's also a listing for as yet unborn animals, which would seem to defy the general principle of contract that you have to have an actual existing item in order to contract for it. However, these are things that arise commonly in Vermont agriculture and forestry business. So that's one way that Vermont's UCC reflects the state's unique legal and business needs. The Battle of the Forms refers to the fact that the UCC Section 2201 says that UCC sales must be in writing, but between merchants it requires only that some writing exist that's sufficient to indicate a contract for sale has been made between the parties. So an order form, an estimate form, some emails back and forth, some receipts. Those are some things in writing that indicate there's a contract for sale. And then if the parties are merchants, it's also enough that that writing just be provided within a reasonable time. So the bill of lading that goes with the shipping, that set of papers that comes on top of your order when you from Amazon, that's taped to the top of the box, those are the writings. So the Battle of the Forms occurs when merchants tweak the terms of the agreement by sending a so-called receipt that has different terms than the original order or offer. Courts will usually allow these changes if the actions afterwards appear as if the person has accepted the terms. So if I order a refrigerator on Amazon and something different comes, but I accept it and don't return it, then I'll be deemed to have that their form will have won, and I will be deemed to have accepted the item. The only things essential for inclusion in the writing between merchants is the signature of whoever's being sued for enforcement and the quantity of the goods sold. So courts know that merchants who buy and sell things on a daily basis will change terms based on availability. If I have a store and I order, 500 purple stuffed teddy bears, and what arrives are, 3 purple ones and 97 pink ones, doesn't matter. I'm going to stick them on my store shelf and buy them. So the UCC assumes that that kind of change will be okay unless there's a prompt specific response in writing rejecting the goods that were shipped. Article 9 refers to security interests, and that's when one party, the debtor, or the creditor, one party, the creditor, gives credit to another party, the debtor, with a right to seize the property or collateral if the debt is unpaid. Perfection by possession is when the lender will hold on to the item and keep possession of it until it is completely paid for. So some lenders will hold on to stock certificates or other monetary collateral to be kept and sold against late payments. Bail bondsmen and pawn shops also will hold on to collateral for the money that they have loaned you. And the other way to perfect those liens in a security interest is perfection by filing the UCC1 form or a financing statement. There, I've posted both a blank and a filled out UCC1 for you to take a look at, as well as a short video by a Maine law firm on filing UCC1s. Consumer goods sold on layaway or other store financing schemes are considered perfected as purchase money security interests, and that means the store can repossess the item that you bought on credit. Furniture rental firms with lease to own deals are notorious for doing this, and if you miss one payment, they'll bust into your house and take all the furniture back. And if you default on a secured transaction, the creditor can take possession if it can do so without a breach of the peace, or they can file suit in court, but you still owe the rest of the money. So if that furniture rental company comes into your apartment when you're not home, takes all your furniture back, you still owe them the rest of the money that you had contracted with. The same thing for cars and car repossession. If you have a financing loan on your car, and you do not make the payments, what will happen is in the middle of the night, a repossession company will come and take your car away, and you still owe the rest of the money on the car, and now you are out the car.